Hello and welcome to another episode of The Legals with Gracie and Kate. Today we're going to talk about just a general overview of immigration law as a whole. Talk about the sources of immigration law, the different divisions, and just generally immigration law 101. So first let's start with the sources of immigration law. Now immigration law is federal. It's a federal entity, federal sources. So you have the immigration laws, which is found in the Immigration and Nationality Act, also called the INA, and that's under Title 8 of the United States Code. Then you have Code of Federal Regulations, also called CFR, and that also is under Title 8. And then you have case law coming from the U.S. Supreme Court, from the U.S. Court of Appeals, and also the Board of Immigration Appeals. And then lastly, sources of immigration law include ICE and CIS memos. For example, DACA, or the DREAM Act, is not something that was a law passed by Congress. It was a memo saying this is what our policy is going to be for the Dreamers. Same thing with people who were from Haiti, undocumented, or even as tourists, and during the time when the earthquake hit. The ICE USCIS memo determined that these people would get special status. They wouldn't be put in deportation proceedings because of the things that were going on in Haiti. Same types of thing happened for people from Guatemala, people who were under Pinochet. So different times in history, there's different memos that put forth a policy saying, as a policy, even though it's not a law, we are not going to deport these certain people. All right, let's talk about the different entities of Department of Homeland Security, DHS. First, you have USCIS, which is also called Citizenship and Immigration Services. So CIS, Citizenship and Immigration Services. Their job is to adjudicate affirmative applications. Now, what that means is if somebody affirmatively goes to CIS and says, I would like a student visa. So they affirmatively go, apply for some type of status, the student visa. You go to CIS. If somebody is in the United States and marries, let's say they're here on that visa, on the student visa, they find the love of their life and they marry the person, and they want to change their status from that of a student visa to getting their green card. Again, that's an affirmative application. Somebody wants to apply for their citizenship or to naturalize. That's also an affirmative application. Adjustment of status. Anything where an individual affirmatively goes to CIS because they know they qualify for this immigration status. So you affirmatively go to CIS to say, I qualify for this, and I would ask that you grant me this certain type of status. That's all affirmative applications that are adjudicated by CIS. All right, next we have CBP, which is Customs and Border Protection. Customs and Border Protection is exactly what it sounds like. It conducts border inspections, which includes inspecting people's documents and also inspecting their luggage to make sure they're not bringing things into the United States they're not supposed to. Like the most common thing is endangered animals or some types of fruits or agricultural products, because the United States has to be careful, as do other countries. We don't want to be bringing this product into the United States because we don't know how that plant, if the seed is thrown out, is going to affect the native plants. So it's not just people, it's also plants. But of course, mostly we look at people themselves. Now, the thing that's unique about Customs and Border Protection is that they can order an expedited removal without a hearing for certain individuals, usually at the port of entry. So where this would come into play, for example, is you're coming from Mexico, and you had a green card, but your green card expired because they're required to renew it every certain number of years. So have a green card expired, you didn't notice, and you went to go visit family in Mexico. You come back across the border and they look and say, your green card expired a month ago. Because you had been a green card holder, you don't, your green card is still expired, so they could do expedited removal without a hearing and turn that person away immediately. Another example, someone who I knew had been in the United States working at a summer camp. She was quite young, 20 years old, worked there for 6 months. And then after her 6 months were up, she went back to the UK, and within a month turned around and came right back. Now, Customs and Border Patrol, also known as CBP, said, wait a minute, you're 20 years old, you were just here on a 6-month visa, you turned around and you came right back. You're too young to have the kind of money to do this. Why are you coming back? And she said, oh, I'm just coming back as a tourist. Again, they're like, wait, you just spent 3 months working in a summer camp, then the next 3 months you were being a tourist, and this quickly you came back. That doesn't sound right. So they detained her for several hours, and eventually she said, okay, you're right, I was coming back to work as a nanny. So they then ordered expedited removal, which meant they turned her right around and sent her back to England without any type of a hearing on whether or not she should be removed from the United States. Now, removal and deportation are the exact same thing. Different lingo, means the same thing. Just every number of years, there's some kind of lingo that gets changed by policy. But removal, deportation, same thing. All right. The next thing is who can be removed from the United States. First, only non-U.S. citizens can be placed in removal proceedings and or removed from the United States. So only non-U.S. citizens can be placed in removal proceedings or ordered removed from the United States. However, that doesn't mean that if somebody, let's say, somebody applies for citizenship. So somebody applied for citizenship. A good example of this is the Nazi concentration camp guards. They come to the United States, they apply for citizenship, they get their citizenship, they live in the United States for 20 years, and then it is discovered that they were a guard at one of these concentration camps. They still cannot be removed because they're a United States citizen. However, they can have their citizenship taken away because naturalization is the process of getting your U.S. citizenship if you weren't born a U.S. citizen. And in the naturalization application, one of the questions is if they've ever committed violent crimes overseas, if they've ever done subversive actions overseas, if they've ever been, done such heinous crimes as being guards at a concentration camp. And if they said no on the application, and it was determined decades later that they had in fact lied, the citizenship can be taken away, and then they can be removed or deported. It's a two-step process, 2 different courts, 2 different proceedings, because non-citizens are the only ones can be removed. So even if they gain their citizenship under false pretenses, they cannot be removed until the citizenship is first taken away. Then they can be removed. All right. So again, who can be removed to the United States? A second general statement is that a criminal conviction committed or suffered after an individual becomes a U.S. citizen cannot cause that individual to lose their citizenship. Well, the conviction itself doesn't cause them to lose their citizenship. However, again, even though a U.S. citizen cannot be removed, that criminal conviction doesn't get their citizenship taken away, generally speaking. But here's the catch. Let's say I am from Spain. I go to New York. I rob the Museum of Fine Arts, steal a painting worth $2 million. And then 6 months later, I haven't been caught. There's no leads. They don't know who's done it. 6 months later, I decide I'm going to go ahead and apply for my U.S. citizenship, and I do it in the proper procedures. I have all the paperwork in order. Nobody knows I've committed this crime 6 months earlier. So I get my U.S. citizenship. Another year and a half passes, and it's discovered that, wait, the cleaning lady finds this $2 million piece of art in my closet and reports it, and now it's discovered that I indeed have committed this crime. the crime itself didn't make me deportable. However, the fact that I naturalized after I committed the crime means my citizenship can be taken away, and here's why. Because when you do the application and take the oath for citizenship, you swear that not only have you not been convicted of a felony or any other type of crime that would stop you from becoming a U.S. citizen, you also say, nor have I committed a crime for which I have not yet been charged. And so even though the crime itself doesn't get you deported, it can take away your citizenship, because then you go through denaturalization proceedings, your citizenship is taken away, and then you're deported. Again, two different proceedings, two different cases, but committing a crime and then becoming a U.S. citizen does not save you from deportation. If you become a U.S. citizen and then the evening of your you become the U.S. citizen at the moment you have your swearing-in ceremony. Now, let's say that evening, driving home, you get really drunk because you're celebrating and you kill somebody. This is a felony. Well, you became a U.S. citizen at the moment you were given the oath. So now you cannot be deported for having committed that crime, and your citizenship cannot be taken away. For your citizenship to be taken away, the crime had to have occurred before you're naturalized, even if they don't find out about it until after your naturalization. All right, let's talk about what is a non-citizen status includes. Lapper, all there's the green card, also known as the lawful permanent resident, also known as LPR, also known as LAPR. So lawful permanent resident, LPR, LAPR, green card holder, all the same thing. Then you have the non-immigrant visas, which includes the tourist visa, which is the B1, a student visa, which is an F1. Then there's also special visas like the S visa, which is informants, the U visa, which is for victims, the T visa for human trafficking victims. So, for instance, U visa for victims of crime because they want that person to be present to testify about the crime committed against them. Just because you are a non-U.S. citizen and a crime was committed against you, and whatever prosecuting entity, be it state or federal, is prosecuting that crime, that does not mean that you are going to get a U visa. You don't get it automatically. They're actually quite hard to get. So, for instance, the crime that you were a victim of was, you're at a bar and somebody started a fight and you got hit. And somebody battered you, or somebody assaulted you, or you were in a relationship with somebody that you're here on as a student visa. You start dating your classmate. He's a U.S. citizen and he batters you. The vast majority of these people are not going to get a U visa because there's a very limited number that they give out. Now, what would be an example is more of a high-profile crime. For example, there was these two gentlemen from China who they became U.S. citizens, but they were doing a bunch of banking laws with China and had a lot of connections to the Bank of China, and they stole $1 billion from the Bank of China, $1 billion. So, of course, this is very politically important to the Chinese government and the United States government in terms of very rarely do the governments cooperate with each other, but in this situation, it's more than $1 billion. So, it was something the U.S. government was very interested in working with China to prosecute. The wives of these two men did not have their U.S. citizenship, but they were victims of the crime, not because they were stealing from the Bank of China, but they were victims of other crimes that these men had committed. They were abusive and all kinds of other domestic types of things that they had done against these women. Without their husbands, these women didn't have status in the United States. And of course, if you're a sponsor and you're in your first 2 years of your green card, and your sponsor isn't able to or isn't eligible to further sponsor you, no more green card. But for these women, the federal government wanted them to stay in the United States. So they did offer them the U visa because they were victims of crimes. But in return, these women would testify against their husbands about the who, what, when, where, how of stealing all this money from the Bank of China and what did they do with it. So the S visa, so informant, somebody who's an informant against the Italian, the U.S. version of the Italian mafia, but they're here in the United States and had been working with the family, and they're working as informants. So something high profile. Victims is a U visa, and the T visa is human trafficking. The T visa is actually much easier to get because it's a policy determination that if you discover that somebody is the victim of human trafficking, be it for forced labor at a house, forced sex, different things that we constantly see in the news, the human trafficking, much easier to get the T visa. All right. And then you also have the undocumented people who entered without inspection, or they were legally admitted into the United States, but that status expired. So let's say I came in on a student visa, so I legally entered because I came in on a student visa, but then I ran out of money and I stopped going to school, stopped paying my tuition. So I'm no longer a student, but I'm in the United States. That makes me undocumented. Or I entered without inspection at all. So I went through the desert between Mexico and the United States, undocumented. And you also have people who are granted asylum or refugee status. So they're not U.S. citizens. They are still a non-citizen, but they're here under asylum or refugee status. If I'm here under asylum status or refugee status, the stated purpose is once conditions approve in your country, then you can go back home to your country. That's why you're not getting citizenship. So, for instance, if there's a regime empowered, like the Pinochet regime, we're not going to make people go back. A better example is Cuba. We, under the Castro government, certain ethnicities of Cubans were persecuted, so we're not going to send you back. Because there's a significant likelihood of that you will be persecuted if you are sent back. So we're not going to send you back until conditions change. Once the Castro government is out of power, if Castro dies, then perhaps things will change. We'll send you back. But until that person or that risk to your life exists, you are not a U.S. citizen, but you do have status as an asylee or a refugee. And then the last is temporary protected status, so TPS. So people who, for instance, were in the United States when Haiti suffered the earthquake. Now they can get TPS status, so they don't go back. They're temporarily protected from deportation until the things change in their country so they can go back. All right, U.S. citizenship. There's different ways to get U.S. citizenship. Of course, if you're born in the United States, you're automatically U.S. citizen, and that includes Puerto Rico, Guam, and the U.S. Virgin Islands. So those are U.S. territories, but it's still the United States. So you become a U.S. citizen automatically by being born there. If you're an individual born in American Samoa and the Swain Islands, they are not U.S. citizens, but they are nationals and cannot be deported. And the reason for that is it's a unique relationship between the Swain Islands, the American Samoa, related to the war itself, World War II, and they're not U.S. citizens, but they cannot be deported. All right, then the next type of citizenship is derivative citizenship. So you weren't born as a U.S. citizen, but so you're not born a U.S. citizen. Your parent gets you your green card or your LPR status when you're 7. Then when you are 12, your parent becomes a U.S. citizen. Well, when they apply for their naturalization status, they include their immediate dependents, their immediate children, as what they call riders. So as a rider to somebody who naturalized before you, the child, turned 18, you derive the citizenship through your parent. So again, mom and dad bring you into the country. You all come in when you're 6 years old. They get your green card, your LPR status. When you're 14 years old, your parents get their U.S. citizenship. They put you on their application as their rider. You derive your U.S. citizenship, provided you are 18 before they actually get sworn in as U.S. citizens. Now, here's the thing to remember about the derivative citizenship. You have to have, the parents had to have become U.S. citizens before you were 18. You can't have started the process. It needs to be finished. So the vast majority of times, people who apply for naturalization, the riders need to be less than 16 because you're not going to get naturalized in less than that 2-year period. So if you know somebody who is going to get their citizenship, they have children, they have minor children, encourage them, get naturalized before your child turns 16. And then, of course, there's the acquired citizenship. So if you're not born in the United States, but your parents live abroad, they're teachers in China or missionaries in Africa, but they are both U.S. citizens, or actually just one is a U.S. citizen, you then acquire citizenship by nature of the parent. Now, it's easy if both parents are U.S. citizens, and it's much easier to acquire it that way. If just one is, you can acquire citizenship if additional conditions are met, which we'll get into another time. But let's talk about naturalization. Naturalization, the requirements is you must be 18 years of age. So, and that's why when we just talked about being a rider and derivative citizenship to a parent who naturalized, in order to apply yourself, you have to be 18. But once you turn 18, you have the ability to apply yourself, so you can no longer be a rider on somebody else's application. You have to have been a green card holder for 5 years. It's less if you're doing it under marriage, which is 3 years. But generally speaking, you need to have been a green card holder for 5 years and have good moral character. And good moral character obviously means, if you have several DUIs and several battery against the household members, that's not good moral character. Now, Supreme Court case law has said one DUI does not disqualify you for good moral character. And of course, to naturalize, you have to go through the application process, and you cannot apply while on probation for any offense whatsoever. I had somebody who was on probation for disorderly conduct. They were out celebrating. People had been drinking. They got a little bit too loud. People called and complained. They got cited for disorderly conduct. So it didn't disqualify him from naturalizing, but he could not apply to naturalize until he had served his probation period for the disorderly conduct. Now, if you're getting your citizenship, and that's if you're naturalizing. If you're getting your citizenship through acquired and derived citizenship, the citizenship is automatically conferred without any other certain conditions. There's no discretion, and criminal history cannot constitute a bar. So if you acquire citizenship through your parents who they're U.S. citizen missionaries in India, and when you were home on visiting your relatives when you were 14, and you and your friends went and shoplifted, there's no discretion. There can't be that criminal history cannot constitute a bar to your acquiring that U.S. citizenship. Now remember, naturalization, on the other hand, is a discretionary process, and all criminal history will be taken into account, as I just said about the DUI. Several DUIs, several battery against a household member, that's discretionary, and the reality is it's very unlikely that you'll be given your citizenship because you're showing you're not somebody who we want as a citizen. One DUI probably will be given citizenship. All right. There's so much more we could go over, but because immigration is such a complex topic, we're going to stop there. And next time we'll talk about immigration detention in terms of who can be detained, how they can be detained, what's the process. But for now, that's Immigration 101. Enjoy your evening and enjoy your week.